Hi, it's Mike DelSignore, Massachusetts OUI lawyer. In today's video, I want to talk about what happens if you're charged with OUI and your case is going to be heard in the Plymouth District Court. I've been handling cases from Plymouth District Court for years. I know the judges very well there. What's going to happen is your first court date, you're going to face an arraignment. Be formally notified of the charges. If this is your first or even second OUI, you're released on your promise to appear in court at a future court date, generally with no bail. If the case is unusual, you might have conditions like alcohol-free. You could have a nominal bail potentially if it's a second offense. But generally, bail's not an issue unless it's a third offense. At a third offense, you may face some bail. Common bail will be $500, maybe $1,500 max, and sometimes you'll be on conditions like alcohol-free with a sobriety where you have to take a breath test 2 or 3 times a day to make sure you're not drinking. Cases in Plymouth District Court start in the first session. After the first court date, your next court date will be the pretrial. At the pretrial, generally speaking, we'll get the rest of the evidence in the case. We'll see what the strength of the case is. If there's video, they should provide it. Sometimes there can be multiple pretrials. It's not uncommon for the DAs to need more time to provide evidence. But your next court date will be not a trial, but a pretrial. The idea is to give you all the information that the government intends to use to prosecute the case. And then from there, what we do is we determine whether it's in your best interest to take the case to trial or to try to work out a resolution. If you work out a resolution, typically that'll be right in the first session where we'll enter a plea. On a first OUI, typically you would receive a continuance without a finding. If it's a second offense, there's a couple different ways it could be resolved. One of the resolutions is a Cahill, which is like a second chance first offender, where you get the same treatment as a first offender, but you're going to have to get the interlock device in your car. The other second offender resolution requires you to do a 14-day inpatient program. So let's say you want to fight the case. If you want to fight the case, there may be some motions. So motions are usually heard upstairs on the 3rd floor in the Plymouth District Court, where a motion is when you try to contest some legal element of the government's case. You try to get some evidence excluded, such as a breath test. It could be a blood test. It could be statements. We could be alleging that your statements were taken in violation of your rights under Miranda and that they should be excluded. We could also be challenging the stop, saying the stop was unlawful. So if there are any motions, that will be done on a later date. Generally, it would go arraignment, pretrial, motion, and then potentially a trial. And you could always resolve the case anywhere along the process. And you're generally not going to, your disposition, the potential resolution is not really going to be any different if you fight the case a little bit and decide you want to resolve it. Sometimes people think they want a trial, and then after a motion, they might just change their mind. So happens all the time. It's not a problem. You can always reassess, reevaluate. Sometimes life circumstances change. But what our goal is, when I have a client that I'm helping with an OUI, I want to help them make the best decision for them on their case. So we'll talk about it, talk about resolving it, we'll talk about the benefits of doing motion, the benefits of taking it to trial, and what the potential outcomes are. You know, on a first OUI, generally you're not going to be punished for going to trial. So on a plea, a person would get a continuance without a finding. After trial, it'll be a guilty typically, but the terms of the probation are going to be almost identical, where you have to pay money, do an alcohol education program, and have a 45-day license loss. So if you're charged with OUI in Plymouth District Court, keep these things in mind. First court date is your arraignment. Next court date will be pretrial. Then there'll be, if you're pushing the case towards trial, your lawyer and you will have a conversation. Are there motions, legal issues? Should we try to fight a certain aspect of this case to make it better for trial? Final step is a trial, whether it's in front of a judge or jury. Jury, 6 people chosen from Plymouth County. They have to be unanimous. A bench trial is just the judge alone. And that's something I talk to clients frequently about, is whether it's better for judge or jury. I use my experience in that court to inform that decision. So those are the steps. What I do always with all my clients, regardless of the outcome, if it's guilty, not guilty, I always help the person get back on the road, do whatever's necessary to facilitate the restoration of the license. Sometimes if somebody admits to the charge, they want to get a hardship license. I handle all that, and I include all that in my fee and in my service to you, because I want to make sure that you get back on the road. Ultimately, that's the goal, is one, avoid a conviction, 2, get your license back. I'm here to help you accomplish those things. And if you want to reach out, call, text anytime. My cell number is 781-686-5924. My passion is helping people charged with OUI cases, and I've handled cases for years in Plymouth District Court and courts throughout Plymouth County. I'd be happy to help you.